Good morning or afternoon, everybody. My name's Virginia, and I'm happy to host this side session to the UN Responsible Business and Human Rights Forum. I hope you're all joining with an eye on trying to achieve remedy for victims. And we're really grateful that the organizers have facilitated this side session because in today's globalized economy, we see only too often that companies continue to operate with impunity and use strategies to avoid responsibilities for human rights abuses. And we are hosting this session together with our partners from the Mind the Gap Consortium. I should go and click on a clicker link right now. I apologize for 1 second. I am trying to see also where you are seeing what you're seeing right now, and that's currently not the case. So I'm a bit lost in where I am in the session. So in any case, we're happy to host this side session with the with our consortium, and we've started out this project 3 years ago with the aim to expose harmful corporate strategies that result in the avoidance of responsibility for impacts, because we see companies operate with impunity, and only too often we're seeing that victims are trying to achieve remedy, and they don't seem to manage this. And so in this project, we not only wanted to expose the harmful corporate strategy that results in the avoidance of responsibility, but also strengthen civil society to implement counter strategies and advocacy strategies to ensure that companies can be held accountable. And we're happy to have this session here today with all you and our consortium of organizations around the world. And with our Asian partners here, we'll be presenting the framework of harmful strategies that we have developed as a consortium, and present some examples of how this plays out within an Asian context. And next, we would like to also discuss and brainstorm with you about potential civil society counter strategies to ensure companies can no longer operate with impunity, and talk through some advocacy and policy opportunities. The speakers to this session are Maisie Bakes from SOMO, Johannes Wasigede Poraka from Incruspana, and Chris Potts from the European Coalition for Corporate Justice. Unfortunately, our fourth speaker, Bhumika Chaudhuri from Cividep India, is not able to join us, so we will do our best to make sure we cover for her and share with you the insights from how harmful strategies are at play in India. The speakers will all briefly introduce themselves, but I will be moderating this session for you today. My name's Virginia. I'm project coordinator of the Mind the Gap project at SOMO, and have worked on developing the framework of harmful corporate strategies. And when we started out this project, and are now working on developing a toolkit for civil society with counter strategies, how to hold companies accountable. So we've published our research in 2020. It's available at mindthegap.nl. NGO, and there we have laid out 5 examples of harmful strategies and 25 sub-strategies. Maisie Biggs will first be presenting our research on these harmful strategies. So I'll hand it over to her in a second, but already wanted to let you know that at the end of the presentation today, we also would like to have an interactive part during this session, and we'll be asking you to go to menti.com and click through the passcode you see on your screen. So you can also give us feedback and input to enrich our research project and give feedback to the potential counter strategies that we have already identified in the presentation. You should be able to see a question box and are able to ask us questions. You are able to do so throughout the session, and I'll be moderating and seeing who has questions, and we'll ask the presenters to quickly or briefly pause and give responses to that. So, Maisie, may I be giving you the floor to take us through the presentation on the framework of harmful corporate strategies.
Sure thing. And we can hear me? Brilliant. I'll be discussing briefly the Mind the Gap framework itself. And this is sort of the first part, as Virginia discussed. We're now moving on to the second part, which is developing counter strategies. But in order to do that, we thought it'd be valuable to do a recap and to talk about what exactly we mean by harmful corporate strategies and give some examples, and then we'll be talking through some of the case studies with our partners. What do we mean when we say harmful strategy? Within the Mind the Gap project, we've discussed how we've defined this as a series of actions taken by a company that results in avoiding responsibility for human rights or environmental impacts. Now, obviously, we can't be reaching into the mind of sort of illegal fiction. We can't sort of say exactly the intentionality behind these. But what we can say, based on our case studies and based on our research, that as these series of actions are consistently resulting in companies being able to avoid responsibility and often liability for the impacts of their operations. And through these strategies, they're very often able to quite consistently externalize risks and the costs of their operations onto communities and workers, often extraterritorially. So what do these actually mean in practice? You'll see when we go through the list of harmful strategies that a lot of these are not only legal, but they're also very widely acceptable normal parts of company operation, especially those of multinational entities. Some of the strategies that we discuss are, again, widely accepted and often encouraged by managers, consultants, auditors, probably for the very reason that through these you can quite effectively externalize risk for transnational business operations. But these are, while they do serve business interests, we've observed that these strategies have often quite devastating, harmful impacts on society more generally, but also specifically on communities, on indigenous groups, on workers, and the environment. And these are often made possible by larger, more systemic power imbalances. So here are the 5 general categories. And as Virginia mentioned, these are all available. We have the research available on mindthegap.ngo. So if I talk about anything today that you want more insight into, to read the case examples, to learn a bit more, you can look onto the website. This is available there. But the 5 that I'll be discussing quite briefly in the time that we have today are the 5 categories of constructing deniability, avoiding liability for judicial strategies, distracting and obfuscating stakeholders, undermining defenders and communities, and utilizing state power. And I will explain what these categories mean. For constructing deniability, this refers to the kind of strategies that companies use where it comes to more like the structural side of things. So pre-setting up operations so that when harms materialize, they can avoid liability and avoid responsibility for harms that occur during these operations. Classic one that I think our audience might be quite familiar with is hiding behind complex supply chains, constructing manufacturing and operations in such a way that there are many tiers between a lead company and the parts of operations that might lead to harms, outsourcing high-risk activities, outsourcing recruitment and employment. Again, when there are potentially higher risk operations occurring, companies will often outsource these in order to avoid incurring any possible risk or avoid responsibility for harms that come out of these higher risk activities. Disengaging irresponsibly is another classic one. In this way, when a harm does materialize, when community is seeking remedy, companies can often disengage in a way that can leave a jurisdiction or leave a sector or sell off the assets that are sort of causing these problems. That way, leaving communities with little to no possibility of ever seeing remedy for the actions that occur. Refusing to disclose is another one, is another strategy which has proven to be a really material one, which stands in the way of a lot of communities attempting to seek remedy, because it speaks to those structural imbalances that we discussed earlier. There's different access to information, and often companies' refusal to disclose information acts as a major barrier between communities, workers, and remedy. Refusing to disclose can also have other material impacts, such as if there is, for example, a toxic waste spill, and if a company refuses to disclose the chemicals that might have been involved in said spill, that also is not only preventing remedy, but also acts at communities or even countries' ability to respond to said harm. So these are what we mean by corporate harmful strategies under constructing deniability. The avoiding liability through judicial strategies. This refers to, these ones we probably are all quite familiar with to a point, but these strategies generally involved abusing the judicial process. Again, this speaks to the resource imbalance that can be between companies that are facing sort of pushbacks for harms that have occurred and the communities or workers who have been impacted. One has a lot more money than the other party, so one is able to engage and sort of deal with litigation for a much longer time and use that imbalance in order to basically exhaust the other party. Engaging in jurisdiction shopping, taking states to international arbitration, or threatening to take states to international arbitration is another classic example. Shielding parent companies. This one is, I think, a classic one. It's one that we've seen a lot of litigation regarding, especially in the UK and the Netherlands. And settling cases. And what we talk about here when we refer to settling cases is how when, especially we see when there is litigation and when it actually looks like there might be some precedent starting to be set in the courts, companies will often then resort to settling cases with that particular community. And often the way in which these cases are settled is very exclusively for the particular communities who happen to have representation in that case, as opposed to all of the impacted parties. Distracting and obfuscating stakeholders. This one refers to the company tactics when it comes to stakeholder engagement, to the rights holders who who have been impacted by the harm. Symbolically engaging communities is one that is quite notorious because it will generally involve engaging communities who have been impacted, but doing so in bad faith, doing so in a way to draw out, to distract communities without ever actually assuring them remedy or to try and actually fix the situation that is at hand. Disseminating distorted information. This one can be at both the community level, but also more generally when it comes to sort of bogus scientific outputs or studies that are funded in a non-transparent way. Engaging in fraudulent activity is a more extreme version of that and starts to fall outside of the less legal strategies that we discuss here. Abusing standards. This one refers to a lot of the existing sort of certification schemes or sort of due diligence standards, which a company may say that they're fulfilling and using these as a shield to distract from the fact that they're not actually doing what is necessary to ensure that their operations are not causing human rights and environmental impacts. And diverting complaints through operational grievance level mechanisms. Again, this is a way of taking a complaint, taking a community or worker issue that's raised to the company and basically engaging with them in bad faith dialogue for long enough that either time runs out on a more sort of hard law claim or exhausts the parties that are involved. Undermining defenders and communities. This is sort of a theme that you might see emerging, but this one sort of talks a bit more explicitly on how this can manifest. And again, some of these start to become illegal. Attacking human rights defenders is something that is on the rise. We've seen specific people observing how within a shrinking civic space, human rights defenders are increasingly under attack. And this might not be, in most cases, able to be directly attributed to a company because people are sort of smart at covering up their tracks. But human rights defenders are increasingly coming under attack when they call out harms that are being done to their communities by especially large infrastructure projects. Filing lawsuits to intimidate critics, including slap suits, defamation proceedings against human rights defenders and journalists who speak out about company harms. Criminalizing human rights defenders fits also within this. Dividing communities, often, again, talking about that power imbalance that some communities are facing, you know, when they're faced with these vast resources and also selecting some parts of the community in order to provide remedy to them and not others. All of this divides communities that might otherwise need to be trying to counter corporate harmful strategies. And within this, undermining unionization. Finally, utilizing state power. This corporate strategy refers to the sort of state corporate nexus. This can take manifest in multiple different forms, exploiting preferential treatment by states, for example, by using special economic zones in which certain labor or human rights standards are lowered, avoiding regulations through corporate lobbying or sort of undermining any potential increase in corporate legal accountability. This one is a problem everywhere. And happily, there's been quite a lot of work toward transparency around corporate lobbying and how this relates to regulation. Aligning with suppressive state institutions. This manifests in many different forms, whether it's exploiting like state prison labor or whether, taking advantage of or using products that have been produced through state-sponsored forced labor. We've seen a bit more discussion around this topic. And then engaging state security forces. There have been multiple cases, and again, if you want to look at mindthegap.ngo, we can explain some of these in more detail. But there are circumstances where calling in the army on protesters is not a proportionate response. And we can see companies using things like this in order to say, oh, that was the state that engaged in this conduct, not us. but it is a corporate strategy to avoid responsibility. So these were the 5. We're going to have some discussion around case examples, but as we'll be discussing in a little bit as well, we don't want to be ending on this like slightly downer note. We'll be also talking about countering these harmful strategies and a lot of the really interesting, hopefully trying to capture some of the really interesting and innovative work that CSOs are doing in this space. So I'll hand back to Virginia. Thank you for stepping through those with me.
Thank you, Maisie, for taking us through the framework of harmful corporate strategies. There's one question regarding arbitration. And the question is, shouldn't states be held to account for including provisions in trade agreements in the first place that enable corporations to sue states for policies that protect environmental and human rights, but are detrimental to businesses? So questioning the whole existence, essentially, of international arbitration and trade agreements.
Well, I think it's a good question, and there has been increasing attention in the last couple of years as to the role of both the companies that are lobbying for these inclusions, but also the states that are actually signing these agreements. Our focus on this project is specifically to do with the company side of things, because I think with this one, for example, and also a lot of the examples I just discussed under utilizing state power, we can easily just look to what the state's doing and the wrongdoing of the state, which is also very important. But I think what is also important that we're trying to point out with the Mind the Gap framework is that companies aren't sort of blindly following these along. They're actively bringing these cases. They're using this opportunity. So while there's a very good question and discussion that is ongoing there regarding states' roles in signing these trade agreements with these provisions within them, it's also companies using them, and often using them in sort of ways to intimidate, because they might not even have a claim properly under based under these trade agreements, but they can threaten, and these things take a lot of time and they take a lot of resources. So that's also a strategy in itself.
Thank you, Maisie, for elaborating. We don't have time to touch on this issue during this session, but more generally to say that within the Mind the Gap project, we're also focusing on closing governance gaps that allow companies to make use of such harmful strategy, and the whole existence of these trade agreements is problematic, and as civil society we have recognized this, and one of the policy solutions would be to significantly alter such trade agreements and international arbitration possibilities. I don't see more questions for Maisie at this point, so I'm happy to go to our next speaker, which is Gede from Spain and Indonesia. If somebody happens to have a question regarding our framework on harmful corporate strategies, please write them down and we can get back to the questions towards the end of this session. So for now, Gede, thank you for joining. You have an interesting presentation for us to discuss the impact and the community struggle to address the impacts of nickel mining in Indonesia. If you can briefly introduce yourself and then go through your slides, then yeah, that would be good. You can start.
Yeah, hello everyone. My name is Gede, and I'm work as a executive director of Research Center for Crisis and Effective Development Strategies in Brisbane, based on Jakarta. As a research center, we have conducted research on mineral mining industry, particularly on nickel mining. So I want to briefly presentate the PowerPoint. So the mining industry cycle consists of various phases. The first phase is licensing, which includes the determination of the area for the mining industry. The second phase is explorations. In this phase, the open area to become a white mining area has begun. And the third phase is construction, where the basic infrastructures and all facilities is being set up by the company. And the fourth is production operations, and the fifth is post-mining activities. In this phase, we can find various types of company activities that can lead to human rights violations. I will describe several incidents that can lead to human rights violation in certain phases. So, first of all, on the expulsion of Tokarunsi indigenous people. The Tokarunsi indigenous people is located in the central Sulawesi, some part of central Sulawesi, and the other part is on the border of South Sulawesi. This case of human rights violation in the nickel mining sectors have emerged actually long ago and were committed by one of the international mining giants operating in Sulawesi against the indigenous people, Tokarunsi. So the company started mining explorations in the territory of the Tokarunsi customary community in 1986-88, based on contract works during the Suharto administrations. The result of feasibility study and exploration were sent to Company Research Center in Port Colborne, Ontario, Canada in 1970s in the form of 50 tons of iron ore samples. And 3 years later, in 1973, to be precise, the company began construction of its processing plant. In 2012, sustainability in the annual report states that in 2010 and 2011, the company has relocated 57 families of the Karunsi indigenous people who live in production operations area to other places. But however, only few people choose to live in the place provided by the company in Ledu village at Wasuponda district as the location for relocations. The location of the settlement itself in Wasuponda is still in the object of dispute because there are other parties who also claim that the area as the owner. So looking back at the injustice of expulsion they experienced, the Tokarunsi indigenous people fought back the exclusion, which was carried out because the expulsion was carried out without their consent by filing lawsuits. Several high-ranking company officials are being charged with encroaching on protected forests in Seba Hamlet, Mahulana village, Tawuti subdistrict on charge of violating law concerning use of protected forests and law concerning environmental management. So the charge related to the stripping or clearing of an area approximately 4,000 square meters in Seba Hamlet. The Malili District Court ruled that the defendants were not legally and convincingly proven to have committed a criminal act. In this case, the defendant is the company. But on the other hand, the public prosecutor filed an appeal to Supreme Court. So to the Supreme Court decisions dated on 23rd August 2017, the prosecutor's request for case review was granted by the Supreme Court and rejected the company case for case review. So in this case, the lawsuit was won by the Tokarunsi indigenous people. But the existence of the indigenous Tokarunsi people who still live in Dongi village until now has not been fully received recognition from the company. They are even considered to be illegal settlers in the concession area. So, and then their customary rights have not received remediations. So there are several strategies that can lead to violation of access right to remedy used by the company, we can discuss it again. And the second case that I would like to presentate is on the constructions of road access to the mine deposit location. I will move on to the second case, which is about nickel mining infrastructure constructions, which had an impact on environmental damage and the livelihood of rural communities in the area around nickel mining. The village around the nickel mineral mines were hit by a flash flood in around July and August. In two consecutive months, July and August 2010, the flash flood damaged 497 family houses and damaged the agricultural lands and damaged the water sources. Several company management delegates recorded houses and assessed the flood losses, but only provide instant food noodles. In addition, the companies allege that flooding is a natural phenomenon and not a result of mining activities by the company. Several times, people from 5 villages asked the company to meet and discuss the problem caused by the flood, but the company ignored it. The pile of anger that had accumulated and was ignored by the company led to the community protest on August 2010. Several villagers were arrested, but the police did not investigate the impact of the loss and the damage caused by the flood. So to prevent imprisonment and force the company to remediate by providing compensations, the activists held a press conference. This is what's interesting. The counter strategy used by residents was to develop a discourse on the threat of imprisonment and the threat to their life. But the residents who are accused of also building anti-criminalization discourse by stating that the large-scale mining activities, nickel companies, have an impact on environmental damage based on their investigation, because one of the company used to be a part of exploration workers in the company, so he knew about that the company is operating outside the concession zone and it is illegal. And also the activists of the village accused that the local government has turned a blind eye to this activity, this environmental damage activities. So both the company and the local government ultimately guarantee the safety of village activists because of fears that the widespread publicity of environmental damage will affect the company's image and also brings an investigation from central government about the allegations of conducting operations outside the concession zones. And also the heterogeneity administrations fear that their reputation would be tarnished if they remain silent. So fearing an investigation into illegal mining would be carried out, the company withdrew all lawsuit against the village activists and agreed to negotiate. However, the company rejected the compensations claim because when accepting the claim was tantamount to admitting guilt. So, faced with accusation by the company, arrest by the police, and threat of imprisonment against the village activists who are thought to have spearheaded mass actions that led to vandalism, the village community demand an investigation from local government. So the local government then, the regency head, initiated the formations of 2 working groups consisting of various elements of the community and local government. The first working group is tasked with investigating the impact of mining road constructions, and the second working group investigating the flash flood. The result of that 2 working group investigations is brought by the villagers to the company and request for the company to respond to the result of investigation. But unfortunately, it was ignored by the company. Instead, the company made a counter study to reject the result of the study by villagers and governments. What others interesting about the case that happens in each of mining phase cycles, that also on the work status of the mining workers. Yeah. Apart from the environmental issues during the constructions and production operation phases, labor issues are also prominent in the regions. In 2010 to 2011, the first phase of smelter construction was carried out by a nickel processing company, and the second phase was continued in mid 2013. So the mining and the smelter construction that took place simultaneously required a large number of workers. Low wages without guarantee of work contracts, job security, and frequent cases of layoff or dismissals during the construction work process, and also the work pressures from unilaterally made company regulations encouraged workers to go on strike. So it's throughout 2014, there were about 10 work strikes, and each strike was responded by the company by dismissals, the workers. So the pretext for the dismissals was based on the legal basis, on the law of number 13 2003 and also the decree of Minister Manpower and Transmigration, by classifying the strike as quote unquote illegal strike. And because of that, because of illegal strike, workers are considered absent from works. So the state, in this case, we can see that the state provides opportunities for human rights violations when the laws used to regulate the fulfillment of the right to strike are actually used by a company to retaliate to the workers who demand the fulfillment of their rights. So I think that is a very clear example that undermining the fulfillment of organizations' collective rights to strike through the law is one of the tactics used by a company in the framework of a strategy to attack communities or human rights defenders. The workers' counter strategy in dealing with the company retaliation efforts continues to be carried out by expanding their networks and assisting with the activists and NGOs in the provincial capital. So the aim was to make union organization and the strike was more organized. This effort was put to test in mid-March 2014 when 320 unionized workers went on strike again for 5 days. So a more organized strike made company improve the quality of their counter strategy by utilizing violence through state powers to the deployment of military and police officers, local thugs, and labor union formed by the company to dissolve the strike. So following the strike, the company retaliated again, apart from dismissing striking workers on the grounds of being absent from work for 5 consecutive days. They also mobilized thugs to carry out intimidations and violence in workers' settlements. Regardless of whether the strike was legal or not, the workers' counter strategy has succeeded in forcing the regency head to summon company management to negotiate. Yeah. As a result, many of the contract workers were assigned to become permanent workers, and casual daily workers were made contract workers. So in this case, at the point where the labor aspect began to appear dominant, the reciprocal actions of three parties, company, government, and also workers, begin to show a kind of continuity and discontinuity in practice and strategies used. And the second, the combination of two or more strategies was carried out one after another or simultaneously. It depends and also determined by the demands of the communities of workers are better organized or not. So I think, yeah, there are 3 cases that I can present to you public as an example of how the company use strategy and counter strategy that can lead to human rights violations. Okay, I think that would be all. Back to you, Virginia. Thank you.
Thank you. Thank you, Gede, for presenting. I hope this for the audience gives a good impression of how companies use implement harmful strategies trying to avoid responsibility for human rights abuses. There are no questions at this point, Gede. Should they be entered into the question box, we'll get back to you towards the end of the session. So our next planned speaker was Bhumika Chowdhury from Cividep, India. Cividep is a CSO based in Bangalore, and they're trying to educate workers about their rights, and they're trying also to run campaigns to promote corporate accountability in India and internationally. Bhumika is one of the consortium members, and they're helping us to research cases of corporate abuses and harmful corporate strategies in India. And although she's not here able today, I will briefly go through some of her speaking points to give you an idea of how harmful corporate strategies are at play around the world. And she has looked into the impacts of a copper plant in Tamil Nadu, India, where communities surrounding the plant have complained about harmful health impacts from the emissions, and also research into water, the water in around surrounding areas have been found to include dangerously high levels of iron. And additionally, there was an alleged gas leak by the plant, which led to temporary closure. And there have been many causes of concern for communities. I think since 2008, there's much controversy around the plant. But the protest culminated in a series of protests by many communities, including men, women, and children, protesting to close the company. And the series of protests led to environmental defenders actually being killed due to police violence. And so in looking at the framework of harmful corporate strategies, this to us is an example of how company can may choose to engage security forces by the state that are willing to use violence to defend the company property, instead of the company responding to protesters' concerns about the adverse impacts of the company's operation. And the course of the event is that a largely non-violent movement with genuine concerns for pollution of the environment were met with excessive police violence, which took place as a result of the company actions, because what was found out afterwards is that a coalition of local civil society organizations found that the company has actively sought police protection of its property by declaring there's a grave and imminent danger of the protesters, which was in the eyes of the protesters definitely not true. It was a largely non-violent movement, but the police came in upon the request of the company, and the result was many injured, and unfortunately 13 people were confirmed to have been killed by police forces. And so this is just one of the examples that is at play in around the world, and specifically in the Asian region. It's definitely not the only one, as in doing the research, we've observed other harmful strategies at play, including the exploitation of preferential treatment by states, that companies are profiting from displacements by the government. So although the company is not actively displacing communities to make way for the operations themselves, they are profiting from the government doing this for them and exploiting the preferential treatment. Another example is one of symbolically engaging communities, where we've seen companies promising community improvements, while at the same time also engaging in forced evictions. And there are multiple examples of companies filing SLAPP suits against protesters and defenders, but also going as far as criminalizing human rights defenders and suing them for protesting. This is quite harmful, with very harmful effects to the protesters. Often they're engaged in very long processes, having to travel long distances to appear in court, trying to defend themselves, even though they were later found to be not guilty for defamation. And so these are just a few of the examples that are at play that we've observed. There are more to be found on the Mind the Gap website. So as consortium, identifying such harmful strategies was only our starting point. It's definitely not our goal to only provide this framework, but we also want to provide an answer and policy opportunities, or identify policy trajectories that can ensure that companies can no longer make use of such harmful strategies. And that's the second part of our presentation now. And I'd like to hand over to Maisie again, and afterwards to Chris Putz from the European Coalition for Corporate Justice to take us through these follow-up steps.
Well, thanks, Virginia. That was really helpful, and I think it was really good to sort of take the deeply theoretical sounding framework and demonstrate how that manifests in specific case studies, both in Indonesia and in India and elsewhere. So now we're going to discuss the counter strategies toolkit. And I think if we can look at the visual of the PowerPoint, with the point of this toolkit was to help with sort of the more uplifting part of this project, which is developing counter strategies for civil society. The counter strategy toolkit, the idea is that civil society organizations around the world are actually facing a lot of these harmful strategies individually and often sort of in a void. But actually, there are lessons that can be learned, that could be shared, and in order to increase capacity of civil society. So our aim with this stage of the project is to capture that built expertise to better equip civil society and communities to counter these identified harmful strategies. And obviously, civil society, communities, trade unions have tried many different things in trying to fight back against increased corporate power, and some things are more effective than others. So we'd love to also capture even the strategies that haven't particularly worked well for civil society and what lessons we can learn from that as well. So our research approach has been to analyze 20 emblematic cases where often quite protracted conflict cases, where remedy for communities and workers was pursued in the face of some of these identified corporate harmful strategies, and in the face of sort of sustained company pushback, which unfortunately is kind of the norm in these sort of access to remedy cases. Off the back of this, we're undertaking key informant interviews with experts. So with members of civil society, with trade unionists, with lawyers who have been trying to pursue remedy for business and human rights violations for decades, and where they see the best potential counter strategies and what works and what doesn't work. We then plan on testing this resulting toolkit through partner workshops. So this is to say, what we're trying to capture here is that process of pushing back against corporate harmful strategies, that process that civil society goes through in trying to achieve remedy. Often in the reports that are publicly available, we might know a lot about the harms, and we might end up learning about what kind of remedy was or wasn't achieved. But there's a middle part there where civil society, where trade unionists, where community representatives have worked really hard and strategized in order to try and achieve remedy in the face of what seems often really quite almost insurmountable odds. So we want to draw out that strategic work that's being done by civil society and analyze what works and what doesn't. Some of the counter strategies, which this is very early, very preliminary. This is not the toolkit itself, but these are some examples of potential counter strategies that have been identified so far. So this is just to give you an idea, because what we want from you today is to learn more about potential cases that you think might give good examples of counter strategies, even ones that didn't particularly work, and just to sort of illustrate, what we're kind of looking for. What we're learning from some of the interviews, from some of the reading that we're doing is obviously it ends up being very context specific, but there are lessons that can be learned, especially once we realize that if there are particular corporate harmful strategies which are being used by some of the same big companies in multiple different contexts, there are lessons that can be learned for civil society from responding in one country. If the same company through a different subsidiary is doing the same sort of activities in a different country, then the civil society in that country can learn from what's been done elsewhere against the same company. So through this, we're trying to sort of reflect and react against the corporate harmful strategies. And so we're building this toolkit. We want it to be something that is very practically useful and a way of sort of sharing knowledge that at the moment might exist in silos or just inside the heads of a number of very experienced people and experts. One part of this is closing governance gaps. And I won't speak too much on this because this is more Chris, his region. So we'll just like briefly address one of obviously the point of Mind the Gap, the name of it, is how the fact that companies are able to use these strategies, are able to operate in these ways because of these massive governance gaps that continue, the sort of the gap between their power and their ability to operate in multinational contexts and the power of the state or otherwise to hold them accountable. A number of areas that are on screen at the moment that we identified that there has been progress. But again, I might leave this part to Chris and pass forward. I'll talk about these or other areas.
Great,
no
thanks, Maisie, and everybody for joining us today. I'll speak to the element of this project, which is really directed at governance gaps and what can be done and what is being done by various states around the world in order to address some of the corporate strategies which we've identified in this project to date. For each of these corporate strategies, as Maisie outlined, there is at times and often a corresponding governance gap. So if there isn't information available from a company concerning certain harmful chemicals which it uses, for instance, if that information isn't readily available, that's a governance gap to the extent that that company is not compelled to provide that information in a harm situation. Likewise, if in access to judicial remedy, victims bringing court cases against companies, if they are unable to achieve remedy for a whole range of across the board systemic barriers which exist, that as well is a governance gap. So some of the key and exciting areas of public development in this area of closing governance gaps we can see happening currently at the European Union level, as well as in other parts of the world. But I'm just going to use examples from the EU because, of course, the ECCJ, the European Coalition for Corporate Justice, is a European network. Some of the regulation which I'm about to speak about will, of course, is intended to have extraterritorial effect. So will hopefully and is intended to be to the benefit of other project partners in the Mind the Gap project, but also other civil society actors around the world. And we really hope that together with the toolkit which we're developing in the realm of this project, that there can be practical and real life impacts for advocates and human rights defenders and communities and workers in global value chains affected by global business operations of European companies and other companies based in the so-called global north. So one of the first and most prominently discussed legislative developments that we're seeing is the trend towards human rights and environmental due diligence legislation. Human rights and environmental due diligence being, of course, a corporate practice to prevent harm, which we know from the UN guiding principles and also from the OECD guidelines on responsible business conduct. We saw the first legislative move in this area in France in 2017 with legislation which is already in force and basically puts a corporate obligation on French companies to develop a plan to address, well, first of all, to identify the risks that their operations pose to human rights and the environment throughout their global value chains, to engage with stakeholders. That means to speak and to do discussions, consultations with those affected by their business operations, and as well as develop a plan to mitigate all those human rights and environmental risks. There's as well a access to remedy element to this particular law, which improves civil liability, the substantive law on civil liability for victims who have been affected by French corporate misconduct around the world, which can have improved access to French courts to bring claims of harm or of injunctive nature. So that is to say, if there hasn't been harm yet, that potential victims can bring a claim before French courts saying, you know, there may well be harm in the future because this company is not doing its due diligence properly yet. And then the French court can make a judgment compelling the French company to indeed do its due diligence and to prevent the harm from occurring. Such a legislation is also being discussed and be expected to be passed in Berlin, in Germany next week. It's also being discussed in the Netherlands with a, as I understand it, legislative proposal being discussed by the government parties at the moment. Other European countries such as Finland, Norway, Switzerland, Luxembourg have all had or are having quite developed and advanced discussions on human rights and environmental due diligence legislation currently. or in the recent past. So what are some key elements of this type of legislation which respond to the corporate strategies we've been talking about, or the types of governance gaps which facilitate these corporate strategies? A key element, which I sort of already touched on, is the need for civil liability in order to address some of the real judicial obstacles to remediation, or the judicial governance gaps, which we see continue to perpetuate a situation of corporate impunity, leaving victims without redress and leaving victims with the bill to cover the financial cost of their own harm. So an essential element of corporate and human rights and environmental due diligence legislation has to be civil liability to improve the substantive law. So that means extending liability for harm across and further down or further up the company's value chain. We know that companies exercise huge economic influence throughout their value chains, throughout their corporate policies, or lack thereof. And so in line with the whole concept and expected business practice, responsible business conduct of human rights due diligence, if a company is not using due diligence to prevent harm in its global value chain, they should be liable for that harm in line with basic principles of civil liability and corporate accountability. So that's one first element, seeking to address judicial barriers to justice, or the corporate strategies contained within that collection of strategies. Another thing would be transparency. So compelling companies to release information detailing how their global supply chain is structured. So very clear and concise data concerning who are their suppliers, what is their corporate structure in terms of what type of subsidiaries do they own, where do they source their products from, what are the trade unions and other stakeholders represented throughout their value chain, what are their essential risks to the environment and human rights which their business operations pose. In the EU, there is the Non-Financial Reporting Directive, or now called the Corporate Sustainability Reporting Directive. And these types of laws go some way towards compelling companies to show what their risks are and what they're doing to prevent and mitigate those risks. I would just stress again that in order for this element to be really useful, and in order for it to really close a governance gap, we need it to be as literal as possible in terms of the data which is being disclosed. As I said, we need names and addresses and data on manufacturing sites, names of chemicals being used in the production processes, and not only a narrative description from the company about what its due diligence plan is. I would go to another potential type of legislation which is being debated at the EU level at the moment, which is indeed a type of legislation which exists around the world, which is anti-SLAPP legislation. So SLAPP stands for a strategic litigation action against public participation. Essentially, this is a corporate lawsuit brought against civil society defendants or human rights defenders when they start to talk about corporate impunity or corporate harm which is being caused. There are many examples of this around the world when NGOs or trade unions or communities start to talk to the press about the corporate harm that they're victim to, and then they have one of these judicial actions brought against them. This is such a systematic and widespread and harmful phenomenon that in various jurisdictions around the world, there has indeed been legislation passed by parliaments in order to protect human rights defenders from this form of corporate retribution for speaking out, for daring to speak out, and for taking the risk of trying to counter some of the corporate strategies that they've been subject to. So at the EU level currently, there are discussions about an EU-wide directive or law to protect NGOs, journalists, and the like from corporate judicial assault, one might call it, of this nature. So that's another element or closing of a governance gap, which we're seeing at the EU level. I'm not sure how we're doing for time at the moment. If okay, that seems to be okay. Well, I just wanted to highlight as a last element the UN Treaty on Business and Human Rights, which is being negotiated in Geneva at the moment, and which is very complementary indeed to the whole United Nations Guiding Principles policy framework. I think it's incredibly important that we acknowledge that this legislative initiative at the international level gives us the chance to begin to address in law a lot of the existing governance gaps which have been identified by partners in this Mind the Gap project to date. The whole goal of the UN treaty process is to plug some of these gaps based on the evidence which we've seen of how these governance gaps are functioning in real life, the types of corporate impunity strategies which they facilitate. So this global regulatory initiative is indeed a very big opportunity to address many of the well-researched and evidenced cases of corporate impunity and corporate abuse, leaving victims, communities, and workers disempowered and harmed and left to cover the costs of their own remediation. So I would just like to highlight that to conclude and to say that it's a welcome and a very beneficial and hopefully successful initiative to start plugging a lot of these governance gaps that exist at national, regional, and international level. So looking forward to any questions concerning governance gaps and current regulatory initiatives from Europe or indeed around the world that anyone would like to discuss. Thanks a lot.
Thank you, Chris, for helping us link policy trajectories to close so-called governance gaps that enable companies to make use of harmful strategies identified. It's a good addition to seeing how the practices has been laid out by Gede from Incrispena and what Bhumika from Cividep would have liked to share with us, have researched and documented. We have no questions for you, and so that brings us to the last part of this side session, and we wanted you to go to menti.com, and hopefully the facilitators can pull up the slide. Oh, I see that the slide is, the Menti is there, but the code is not visible. We would have liked to take you through a harvest of your experiences in counter strategies, or your experience with cases in which remedy was pursued despite company pushback, because as a next stage in this project, we are developing a counter strategy toolkit to capture experiences by civil society organizations that were successful, and share that with others who are experiencing the same type of harmful strategies implemented by companies. And we have about 5 minutes to see whether there's any input, because we would like to capture the experiences of the audience here today and of others that we've talked to in interviews before. So we can document everything in an online toolkit that will also be available on our website, www.mindthegap.ngo, and we'll be presenting this to the world to see and to help you fight corporate impunity. So you see menti.com and the number 63887316. If you enter that into the website, you can give us your feedback. We'll leave it open also after the session, so you can give us your input and your ideas for countering harmful corporate strategies. If the facilitators can pull up the Menti page in addition to us, then yeah, we can see whether there's any input now. But given the time, I would already like to thank our three speakers, Maisie, Gide, and Chris, for taking us through the research that the Mind the Gap Consortium has started, case examples in Indonesia, and how to link experiences with policy solutions, and trying to stop corporate impunity and help communities access remedy for harm suffered. Also, I'd like to thank the facilitators of the forum and the organizers, the many organizations and contributors who have made possible the forum as well as the site session today, and our facilitators that helped us with the technical issues. Yes, I see there is some input coming in addition to conduct research to counter company arguments as an important counter strategy, a case against Total activities in Uganda, which can indeed be an interesting case for us to have a look at. So if you have any feedback, the Menti link will be available after the session also. And I'm very, very appreciative to see input coming in here, because our knowledge only goes this far, and a regional session as we're able to host today is very valuable to us, and good to see cases that are not yet on our radar being put on our radar now for further investigation. So we're a few minutes ahead of time, but that allows everybody to have another cup of coffee before going to any of the other side sessions, or ending your day or evening already now if you're in the Asia Pacific region. So thank you again, and please visit our website. If you have any feedback for us, you can also reach us via our email addresses, which will now be put on the last slide. Facilitators can put up the email addresses. You'll be able to reach us. If you visit the mindthegap.ngo website, you also find the contact information. And we wish you a very good day. Thank you again for joining, and I look forward to engaging with you in another occasion. Good. Bye now.